must follow. My name is Veronica. I'm a domestic violence restraining order defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you everything that you need to know to win your restraining order hearing. If that is something that you are interested in, you can actually get your free first class via the link in the description box down below. But let's jump right in. These are 3 easy tips that everyone who is facing a restraining order hearing must know. Now, these are things that I, over the past over 10 years I've been doing this, have realized that my clients struggle with, and these are people who have attorneys to set them on the right track. So if you don't have an attorney, it can be hard to realize these things. Number 1, make sure that you stay calm. Sometimes it can seem like when the other side is speaking and they are telling a blatant lie, sometimes it can feel like it will be more convincing to the judge that you are on the right side, that you are telling the truth and that they are lying if you make faces, if you look over at them aghast that they are telling the lie. What is the most convincing to the judge is going to be if you don't react at all. I know that may seem like a little sociopathic, but no, it's not. It's professional. It is what the judge is used to. It is what the judge, who is an attorney, has been trained to do. It is what attorneys do when they come into court, and it's what attorneys instruct their clients to do. So you want to stay calm no matter what. You also want to make sure that you don't interrupt. Now, I've had clients both for criminal cases and in restraining order cases that are poking me in the arm, that are whispering in my ear, "Object, that's a lie. Say objection, that's a lie." And I've seen litigants who themselves will, when the other side is speaking, jump up and say, "Objection, that's a lie." Well, that is not a valid objection. If you're my client, you can go ahead and poke me. You can whisper in my ear. But hopefully when I whisper back, just stay calm, don't react. You'll remember that I told you, you need to stay calm. We need to let the other side speak. And yes, there are certain valid objections, and if you take my course, then you will learn those. And if you have an attorney, then they're going to object when there's a valid objection, but the judge is going to hear both sides. So you need to not interrupt, not speak over the other party, not say objection, that's a lie. It's really hard to sit there, I know, when somebody else is telling a lie about you and just keep your lips sealed. But you have to. Just wait until it's your turn. You will get your turn. Trust that and wait. Number 2, less is more. This is not your opportunity to litigate the entire relationship. This is not your opportunity for total vindication. What this is really about is whether the petitioner can prove by over 50% that a restraining order is needed to prevent future violence. That's it. That's what it's about. It doesn't matter if the other side cheated. It doesn't matter if the other side was a jerk. And when you're talking about these issues and emotions are running high, I mean, I can think about certain nexus that if I have to go testify in court about, emotions might be running high and I might want to get into, oh yeah, and they did this thing. I'd forgotten about it until now, but now I remember, and they were a real jerk. This is not the time for that. It is not going to be convincing to the judge if you get into that. You need to stick to your point. Do not go on and on. If you find yourself talking about a particular subject other than abuse or denying that abuse occurred for more than 30 seconds, check yourself. It's not an absolute rule that you can't go on for more than that time. And if you're representing yourself, you are just going to be presenting your evidence in a narrative format. But if you find yourself going on and on, or I remember something that's not directly related to abuse, and now I want to talk about it, just stop. You're not talking to your best friend. This isn't therapy. This is a judge. This is a courtroom. This is a stranger who's evaluating you and trying to figure out how reasonable you are. And remember, the petitioner just has to prove by slightly over 50% that they need a restraining order. And so the amount that the judge has to basically like one side more than the other is very, very small. And if you go on for a long time and you annoy the judge and you talk about things that are neither here nor there, you're going to undermine your credibility. So make sure that you don't do that. And the judge has many of these hearings, more than 15 probably every single day. Part of the judge's job is to cut people off. What I always tell my clients who want to go on and want to tell their whole story to the judge is, first, yes, you can tell your whole story to me, but second, you cannot tell it to the judge. When you tell me your story, I'll tell you what's important from it. But the judge is going to, at a certain point, tell you to finish up. It might give you a very small amount of time. So if you spent all of the time that the judge is planning to give you talking about irrelevant stuff, how they were a jerk, some issue that has really nothing to do with abuse, then by the time that you get to the point, by the time that you're like, oh, let me get back on track and get back to what's at hand here, what was in the temporary restraining order, and either if you're the petitioner, bolstering that, talking about that, or as a respondent denying that, the judge may be tired of you already, and the judge may say, look, I'll give you 5 more minutes, or I've heard enough from you, we don't have any more time, and just end it right there. So it's really important that you get to the point, and you get to the point quickly. And I will say that especially when I was a new attorney, the last thing that I want is to not bring something up and then we lose the case. And then I think, well, if only I could have included this extra stuff. Sometimes that thought will still come to my head, but that thought is wrong. What I need to do, and what's important that I keep my client on track for, is that we set the fear aside. We focus on the essential issues, and we make sure that on all of the essential issues we are a home run, and that we are not just blabbing, presenting so much evidence that the judge, who's seeing so many of these hearings per day, gets so tired of us and doesn't see the bigger issues. Because what are you going to do when one of these is granted? You're going to appeal? How long is that going to take? At least a year. It's going to be extremely expensive if you are not seeing your kids in that time, you're kicked out of your house. The appeal doesn't do you a whole lot of good. You have to hit the mark when you are at the restraining order hearing. And for that reason, you need to make sure that you stay on point. Absolutely. As tempting as it is to say, let me show the judge all of my texts from my entire relationship so that the judge will see what our relationship was really like. No, you need to pick some. You need to curate it and make sure that the judge sees, here's a sampling of them. And I have them all available for your honor if you would like to see them. But these are the ones that I'm admitting into evidence. And trust me, the judge is not going to want to see all of them. And then it's up to the other side to show those texts that you showed were not characteristic of the relationship. Number 3, listen to the judge. If the judge asks questions, listen to them more carefully than you've ever listened to anything in your whole life. Really listen to them. And when you answer the question, if it's a yes or no question, make sure that your answer begins with yes or no. Look at the judge when you are answering the question. Because if the judge thinks that you should only answer yes or no, you'll see it on the judge's face before the judge says the words. Look at the judge very carefully. Look at his or her face. And I do this as an attorney too, and answer the question. Now, typically I'm not asked questions except for if it's in my closing or at the end and the judge says counsel and asks me a question. My answer better be on point. I better not start, when the judge is asking me about something over here, answering something over here. In law school, we are trained to notice that. And what you're also trained to basically think about that, and it's not always true, is that if someone doesn't answer the question that you're asking, they're being evasive. They don't want to answer your question, and so you lose trust for them. And when you're in the setting of a restraining order hearing where the judge only has to decide for domestic violence restraining orders, over 50% for one side versus the other, you don't want to give them any reason to lose trust in you. If the judge cuts you off really quickly as the respondent or seems to discourage you from putting on your case, that can sometimes be a good sign. So I will tell you that as an attorney, sometimes I will go to a hearing and I'm representing the respondent. The petitioner always goes first in these hearings. So petitioner goes and they sort of fall flat, in my opinion. They present their case, I get to ask them questions, I object to their evidence, maybe they don't get very much in at all, and now it is my time to go. And sometimes the judge will say something like, all right, counsel, we've heard from the petitioner, is there anything you want to add? When I hear that, I know that I have a client next to me who has a lot of evidence, who I've prepped very well. We've spent a lot of time prepping. And I'm very tempted to put on my whole, at least half-hour long presentation with my client. But what the judge is telling me, and this is what experience has told me, and I'm looking very carefully at the judge's face, what the judge is probably telling me, especially if I can look at what the petitioner has said and presented and realize they have not met their burden at all, in my estimation. And as time goes on, and I do this for longer, I put more and more stock into my estimation, right? But do I really want to annoy the judge by presenting for another half hour? And do I want to, if the other side has failed, do I want to add more things that could potentially call things into question? No matter how much I prep my client, maybe my client says something stupid. I don't know. And my background is in criminal cases. I've tried cases all the way up to first-degree murder jury trials. So let's say I have a first-degree murder jury trial, and I have prepared my case. My client, the murder defendant, is going to testify. I have witnesses on my side. But let's say that the prosecution just puts up one witness who kind of sucks, doesn't say a whole lot, and then sits down. Am I going to present my whole case? Am I going to put my client on the stand and open the door to potentially my client saying something really stupid that gets him convicted? No way. Of course I'm not going to. And it's the same with the restraining order hearings. So if you're representing yourself, then it may be a little bit more difficult to figure this out. But just know that if the judge is kind of trying to rush you and you haven't said anything yet, that's not necessarily a bad thing. In that case, I would say very, very much make sure that you stick to the point and don't add anything extra. If the petitioner said that you abused him or her and you didn't, just say that you didn't do so. Just say, I read everything that the petitioner wrote. It's completely false. I've never hit the petitioner. I've never assaulted the petitioner. None of that happened. And just keep it very, very simple. And these are general principles, general ideas. Of course, every case is different, but in general, if the other side has not met their burden and the judge is pushing me along, then I take that as a good sign. And every time that I've done that, I've been correct in doing so. I hope you found this video helpful. Again, if you do have a restraining order hearing coming up, I do have a course on it. It's called Defeat the DVRO. You can go to defeatthedvro.com or click on the link down below for your free first class, which will give you some helpful information that is not on YouTube. And we'll sort of give you an overview of the course so you can see, is this something that would help you? And I think it will. That's why I created it, because I've sat in courtrooms and I wanted to jump up and start representing respondents who are floundering, and I know I could help, but I just can't. I'm there for my client and I have to just help my client. But after giving people advice outside the courtroom and seeing them go inside and implement it, I realized, okay, I have to do something about this. And I started making these videos on YouTube, but then ultimately making a course that gives you a full guide on everything that you need to know.